Hello and welcome. You are listening to an informed take on current events brought to you by law students and staff of Queen's University Belfast. This is LawPod.
Welcome to LawPod, a podcast produced by staff and students in the School of Law at Queen's University Belfast. Today, we are looking at the concept of innocence and miscarriage of justice in the criminal justice system in the UK. Joining us, we have Hugh Southey QC, who is a practicing barrister in England and Wales and Northern Ireland. He's based at Matrix Chambers in London. He also sits as a recorder in England and Wales and a judge of the Grand Court of the Cayman Islands. Thanks for joining us today, Hugh.
Thank you for having me. It's a pleasure.
Hugh, the concept of innocence in the criminal justice system, I'd like to start with a quote from Lady Hale in the Adams case in the Supreme Court in 2011. And Lady Hale said that innocence as such is not a concept known to our criminal justice system. And I wondered what your thoughts were on that.
In many senses, it's obviously right, I think, is my immediate reaction. And the reason I say that is this. If you look at the criminal justice system in a narrow way, in other words, if you look at what the adjudication process in the Crown Court, for example, is focused on, innocence is not a concept that is ever applied in that system. As everyone's well aware, you have to be proven guilty beyond reasonable doubt. And so the court can consider, or the jury can conclude, you're probably guilty, but that's not enough. And indeed, juries are generally told something similar to that. However, in reality, the way our criminal justice system has developed and become more complicated, it means that there are aspects of it that sort of fall outside the classic adjudication process. So, for example, there are systems in place to manage the risk of offending by disclosing details of someone's alleged criminal behavior, even when they haven't been convicted. And in that context, innocence potentially becomes relevant. You talked about the Adams case, and that's probably the clearest area where innocence becomes relevant, because the English system and to some extent the Northern Irish system have adopted a test of innocence when deciding whether people should be compensated when they're acquitted and shown to have been the victim of a miscarriage of justice.
Yeah, I mean, that's we're going to be touching on disclosure sort of briefly. We're going to be touching on miscarriage of justice more substantially as well. But is it fair to say at this point that when talking about the criminal justice system, or at least the kind of mainstay of the process of dealing with criminal prosecutions, innocence really, as a presumption, acts more as a sort of fairness safeguard to people accused of offences going through the system, rather than having any sort of substantive place within that system?
Yes. I, in one sense, even during the adjudication process, the presumption of innocence, as it's called, is perhaps could be said to be a misnomer, because in reality, what it is actually referring to is the need essentially for prosecutors to prove beyond reasonable doubt. And the reason why I think it may be potentially thought to be a misnomer is, I think when properly understood, that need to be proven guilty beyond reasonable doubt has to be understood as meaning you can be quite likely to be guilty, but that's not enough. And I think there are dangers sometimes in the criminal process in sort of losing sight of that by referring to innocence.
Yeah, because ultimately the focus is on the standard to which the prosecution have to prove the case. Otherwise, yeah.
Absolutely.
Okay, so given that it substantively within the adjudication process, and as we will see through this episode, some of the elements in miscarriage of justice, substantively, innocence as a concept isn't defined by law. It doesn't exist within that sort of process. I wonder now if we could get into a little bit about the exploration of the facts in Adams and some of the issues in Adams. And of course, you acted for Mr. Adams in the Supreme Court.
Yeah. Can I just sort of perhaps start by taking a step a little bit back from Adams, just to put Adams in context? The International Covenant on Civil and Political Rights, Article 14.6, provide that there is a right to compensation where, and this is the language of the provision, when a person has been, by a final decision, been convicted of a criminal offence, and when subsequently his conviction has been reversed or has been pardoned on the ground of a new or newly discovered fact which shows conclusively that there has been a miscarriage of justice. That language is complicated, and one of the problems with it historically has been it seems to, in one sense, confuse two different concepts. One is the need to show something conclusively. Now, that might be said, and indeed has been argued historically by the UK government to mean that you need to be shown to be innocent, because showing conclusively suggests that some sort of high standard of proof is required. However, the phrase miscarriage of justice might be thought to imply something different, in the sense that miscarriage of justice can be said to occur whenever the criminal justice system goes wrong. I mean, to put this in context a little, the Adams case was concerned with a situation where the conviction was quashed largely because the trial representation was poor. There were also issues about disclosure. Now, those sorts of things should not happen. You should get high quality representation. You should get adequate disclosure. If that doesn't happen, you might be said to be the victim of a miscarriage of justice. And what Adams fundamentally was about trying to resolve those issues and determine who it was who was entitled to compensation. I mean, the government argued effectively you had to be innocent. We were arguing it was enough that your conviction was unsafe. And what the Supreme Court did was sort of go somewhere in between that, adopting a test which involved you having to demonstrate you couldn't have rationally been or reasonably been convicted.
Yeah, so let's unpick how the Supreme Court viewed Mr. Adams. And of course, there were three individuals whose appeals were conjoined in that case. There was Adams, there was McCartney, there was McDermott. And McCartney and McDermott were the two Northern Ireland cases. Adams was from England. And all three of them, the Supreme Court viewed in the same broad category of cases relevant to the discussion of miscarriage of justice, but there were important distinctions between them. And I wonder if you could sort of take us through the different categories that the Supreme Court thought would be relevant to sort of conceptualize miscarriage of justice.
Yeah, no, absolutely. Firstly, I mean, the Supreme Court identified, particularly in the judgment of Lord Phillips, if I remember rightly, 4 different categories of case where there was potentially a claim. One was where everyone agreed compensation would be payable, was where fresh evidence showed clearly that a defendant was innocent of the crime which they'd been convicted of. The second was that the fresh evidence said, demonstrated rather, that no reasonable jury could convict. That was the category that the Supreme Court also accepted gave rise to a right to compensation, but the government disputed. The third category was that the fresh evidence rendered the conviction unsafe. And that was what Adams was arguing for, because he accepted he was in that category, not category 2, in light of findings that had been made by lower courts.
Yeah.
And then the fourth category was where something had gone seriously wrong in the investigation in the offence, or the conduct of the trial, which resulted in the conviction of someone who should not have been convicted. And I mean, that to explain that category, there was an earlier case called Mullen, and Mullen was someone who undoubtedly did the criminal act that was alleged, but shouldn't have been convicted because there was quite clearly an abuse of process. He'd been unlawfully and informally extradited into the United Kingdom, and because of Mullen, it was agreed by all the parties that category of case didn't entitle someone to compensation, albeit I think before Mullen there was a sensible argument he should have been entitled to compensation, because again, if you apply the language of miscarriage of justice, he was a victim of miscarriage of justice. He'd only been convicted after a process that should not have taken place.
Yeah, and I'm interested to explore this a little further as well. The sort of difference between, miscarriage of justice that is sort of heavily focused on innocence, which is successively where legislative reform has tended to go towards, for compensation purposes, and miscarriage of justice in the broader sense that the actual system has failed the person going through it as the person being accused of an offense. And the distinction is rather interesting when you think of the way in which Adams on the one hand and McCartney and McDermott on the other hand were categorized by the Supreme Court. Of course, in Adams, as you said, he accepted that he was in the third category of the 4-category approach by the Supreme Court, and McCartney and McDermott fell into the category where new evidence undermined the cases that had been made against them by the prosecution at the time that they were convicted. And the new evidence tended to suggest that they should never have been prosecuted to begin with, or that the trial judge would not have convicted them. And that was the evidence relating to police assault at the time that both McCartney and McDermott were arrested, and at the time that they both confessed. So what I find interesting, and I wonder if you might tell us your thoughts on this, is that the point at which the new evidence had undermined the convictions of all 3 people, the fresh evidence that was relevant to both Adams and McCartney and McDermott was relevant at different parts of the criminal justice process, the adjudicative process, and in fact, beyond the adjudicative process. So for Adams, it was during the trial itself, because the unused evidence could have aided the cross-examination of the key prosecution witness. And for McCartney and McDermott, it was the decision to prosecute at all, because the statements that they made, their confessions, might have been coerced out of them. So I wonder, do you think there's a consequential distinction between McCartney and McDermott on the one hand and Adams on the other hand when we're trying to understand miscarriage of justice as a concept?
I think the distinction between Adams and McDermott probably shows most clearly, which is possibly a slightly different thing, but not totally unrelated to the point you've just made, is that in one sense, our courts are not terribly good at sort of trying to second guess the significance of fresh evidence beyond sort of the basic task they have to perform when they allow appeals, which is thinking about whether or not a conviction is unsafe. Now, there are issues about whether or not they're any good at doing that. You could argue that there is an institutional reluctance to find that fresh evidence undermines a conviction, but then to have to apply the sort of distinction that was they needed to apply on the basis of the Adams judgment, I think is quite difficult actually for them. I think it logically, I'm not sure it makes very much difference where at what point in the process the evidence was relevant. If the test is applied literally, the Adams test is applied, the question becomes, could ultimately the defendant have been reasonably convicted? I just think that's a difficult test for the court to apply, and it will end up making what may seem to be distinctions that are difficult to justify.
Yeah, because reading Adams and in terms of trying to, especially at the Supreme Court level, trying to clarify legal principle in a way that is clear, in a way that is sort of certain, in a way that's accessible uh, throughout the UK, it seems that there might be an element of subjectivity in deciding, certain kinds of evidence have a certain impact on a previous conviction that seems greater or lesser in comparison to other impacts. But there's seemingly no objective justification for making those distinctions kind of concrete.
I think that's right. I think whenever you have fresh material, even in the appellate system, when you're challenging a conviction, from a judge's point of view, it's going to be difficult to assess the impact of that fresh material because the judge has an imperfect picture. They don't. They will be working from paper records of what happened at the trial, so they won't really have a direct way of assessing the impact of the evidence of the witnesses rather who gave evidence live. They then have some fresh evidence. They may have heard that orally. They may not have done. But even if they've heard that orally, trying to fit that in to, as I say, a trial process that they weren't part of is inherently difficult. Now, I think my own sort of instinctive view, it's difficult to prove that this is objectively correct, is it is easier to carry out that exercise where you're asking, would this potentially have made the conviction unsafe? Because in one sense, in those circumstances, what you can do is, if you like, adopt the most favourable analysis of the previous evidence, the trial evidence from a defendant's point of view, and then see how significant in that context this new evidence would be. Trying to work out whether or not the defendant could reasonably have been convicted when you don't really have that direct a sort of benefit of having seen the oral evidence at trial is going to be much more difficult. And I'm not sure the system is very well set up to do that.
Yeah. There was an interesting sort of comparison that was made as well by Lord Kerr in Adams when talking about the sort of inability of the criminal justice system to assess innocence or even make findings of innocence, and how inappropriate that would be in this forum. And there was an interesting comparison to New Zealand that he made, that the New Zealand Law Commission suggested a specific tribunal to actually make a finding. And I wondered, do you think that it's the court might be aided by having a specific sort of statutorily established forum where you can sort of hash out arguments, or do you think that actually rehashing what was the original trial might, on principle, be a bad idea?
I think, as a matter of principle, it is not a great idea, other than to the extent it's unavoidable. And it's obviously, because people shouldn't be wrongly convicted, it's obviously unavoidable that you have to look at the trial process to see whether fresh evidence undermines the conviction by making it unsafe. But beyond that, and any of the tests sort of that were proposed by the Supreme Court, other than the one that was argued for by Adams, involves going beyond that. It involves fact finding that I think whoever does it is going to be imperfect. I'm not sure what benefit you get from having a specialist judge, because they still won't be in a position to understand the impact of the oral evidence that led to the conviction.
And in terms of the sort of strength of the evidence that led to the conviction, of course, following the Adams case, the test for miscarriage of justice compensation changed pretty significantly from what it was in Adams, which, I mean, the sort of category 2 case of new evidence undermining the conviction was further restricted to new evidence demonstrating that the person trying to claim compensation never committed the offense. And
yes,
I wondered if you might sort of, because when you talk about the difficulty in assessing the original evidence, sometimes years down the line, I mean, how much more difficult must it be to actually prove innocence?
I think from a defendant's point of view, proving innocence is going to be, in many cases, impossible. I mean, it's not. In one sense, innocence is perhaps an easier concept to apply if you're a judge than the category 2 that we've talked about, the category of cases where no reasonable jury could convict, because the reality is the innocence cases are going to be the ones where there's, for example, DNA or something like that. There is a distinct category of cases where no one disputes that the offender who actually committed the offence, for example, left DNA at the scene, and if DNA testing proves that the individual developments in DNA testing proves that the individual who was convicted was not the person who left that DNA, then you can say positively that person is innocent. So there is a category of cases where, in one sense, it's relatively easy because there is an absolutely central piece of evidence, and you can prove you're not the person who was responsible for that central piece of evidence. But from the point of view of a defendant, if you're not in that very discrete category of cases, proving you're innocent is almost impossible. I mean, the sort of the run-of-the-mill criminal case is not going to be one where there's a sort of decisive piece of DNA evidence. It will be the sort of case where there are a number of, say, witnesses who say what they saw you do something, you might well be able to undermine their evidence by demonstrating that, for example, they had a motive to lie, or they've recanted on their evidence, or all sorts of things. But positively proving then it wasn't you is very difficult, because what you do is you knock out the prosecution evidence by doing that sort of thing. You don't put forward an alternative theory, and proving innocence in that context is likely to be extremely hard. And so for the vast majority of people who've been subject to a miscarriage of justice, I would expect it becomes impossible to prove innocence. And I suspect there are very few, from everything I've heard, there are very, very few successful claims for compensation now.
Yeah. In terms of claims for compensation and the sort of broader understanding of miscarriage of justice that you initially sort of discussed in terms of the system failing an individual trying to go through it. Um, I wanted to sort of briefly look at the way that miscarriage of justice compensation was seen as intersecting with the presumption of innocence in Adams, because there's a part in Lord Hope's judgment where he says the refusal to provide compensation actually doesn't affect the presumption of innocence because it doesn't undermine the acquittal of the person. And while that might be true in one sense, in a sort of formalistic sense, um, acquittal isn't the end of the journey for that person. They have to then reintegrate into society and try and access employment, access various services, the impact that it might have on their mental health, the impact it might have on their relationships with other people. And so I wonder to what extent, is it, first of all, to what extent is the presumption of innocence in that context just a highly formalistic one? But also, secondly, to what extent does it have to be a highly formalistic one? Because all of this post acquittal social circumstances and social impact is not possible to be taken into consideration by the courts at that time.
Yeah, I think just to sort of, as a sort of a preliminary remark, I'd say that the current state of the law, and I'll try and distinguish between the law and my own personal views in relation to this, is a bit of a mess in relation to the presumption of innocence, and particularly it's a bit of a mess in relation to the presumption of innocence in this particular context. The Strasbourg court, in a case called Allen in the United Kingdom, indicated and seemed to state this as a matter of general principle. The presumption of innocence means that where there's been a criminal charge and criminal proceedings have ended in an acquittal, the person who was subject of the criminal proceedings is innocent in the eyes of the law and must be treated in a manner consistent with that innocence. Now, if you apply that statement of principle, it seems to me that to refuse someone compensation on the grounds that they are not truly innocent or can't prove that they're truly innocent is inconsistent with that statement of principle. However, even in Allen, the Strasbourg court adopted a more nuanced approach, and indeed rejected compensation in that case, essentially because of the way in which the conviction had been quashed. There's been a certain amount of argument about what was actually decided in Allen, but so that others may disagree with that analysis, but that's my understanding of how it was approached. Our domestic courts, particularly the Supreme Court in Hallam Neelam, has adopted a completely different approach, which is to say that the presumption of innocence has very little impact, essentially, after you've been acquitted. And the presumption of innocence didn't really apply to claims for compensation after acquittal. all that was prohibited essentially was a public authority suggesting positively you should have been convicted, which is obviously a fairly unusual thing to happen. So I think we're in a bit of a mess. My own view is that if the presumption of innocence is to mean anything, following acquittal, you should be treated as innocent in all respects, and refusing to pay compensation on the basis that you can't prove you're innocent is inconsistent with that.
Yeah, because of course, Hallam Nealon is currently in the Strasbourg court, and the law reform group Justice are intervening in those proceedings. And Justice in 2018 did a very detailed report into the impact of kind of reintegration with society once you've been exonerated um, by the criminal justice system. That you can spend however long in prison and try and come back, and the impact that this has, and the complete shock that it delivers to try and reintegrate, having this hanging over your head that, oh, I was acquitted, but actually I can't get compensation for that because I'm not the right kind of innocent, or I'm not innocent enough. And so I wondered, to sort of go back to the first question that we explored in this episode, and the concept of innocence in the criminal justice system. Should the law try and develop an actual meaning? Because it seems to me effectively that innocence has a place that is not just socially relevant, but in some respects, and especially in miscarriage of justice compensation, effectively legally relevant. But that doesn't seem to have an agreed definition.
Well, yeah, I'm not sure I would agree that that there's not an agreed definition. Well, actually, a better way of putting it is that I think at the moment we're in a situation where there is an imposed definition of innocence, and I say imposed because it effectively is a statutory definition in terms of compensation, because the provisions of the Criminal Justice Act that govern applications for miscarriages of justice does clearly define what is meant by innocence, and it adopts a very narrow meaning. So I think, personally, I think that if you like, the first, perhaps the most pressing issue, rather, not the first issue, the most pressing issue is a political one, which is, I think, politically, it is not desirable that you should have to prove your innocence for the reasons you gave. It doesn't facilitate your reintegration into society. More generally, I think there is a need to resolve, and this probably will involve further litigation in Strasbourg, how the presumption of innocence works. As things stand, it isn't clear how the presumption of innocence works, and that has implications not simply in terms of compensation. Compensation is an important part of it, but it has, for example, implications, as already indicated, in terms of disclosure of criminal records. The fact you've been acquitted can be disclosed, even though it's difficult to see why that would be relevant, unless it is to suggest you might in fact have been guilty even though you were acquitted. So I think Strasbourg, and it probably needs to be Strasbourg, given that the Supreme Court looked at it in Hallam and Nealon, needs to grapple with what the Supreme Court said in Hallam and Nealon and tell us whether that was wrong, and tell us how, as a result, innocence needs to be protected. And I suppose implicit in that, what is innocence? Is innocence simply, as I would argue it is, your conviction being set aside, or is it something more nuanced?
To what extent do you think, because the state of domestic law around innocence, insofar as it is defined, and insofar as it applies in the criminal justice system, there is a bit of a disconnect between the legal concept of it and what might be understood in sort of broader social contexts. And to what extent do you think it's necessary to, when you're talking about innocence and when you're talking about um, the impact from a legal perspective, to sort of take the social view of it, the sort of everyday view of it into consideration, because that is the view that someone exonerated will have to be up against?
Well, my own view is that fundamental to a lot of human rights litigation, a lot of human rights judgments, is the idea that the law will protect the unpopular, the minority who are seen as being lacking in rights. And this is an area where that's true. Unfortunately, our approach to criminal justice means that there are parts of society, parts of politics that assume people who've been before the criminal justice system are likely to be guilty, even if they've formally been acquitted. And in the criminal adjudication process, we're pretty good at protecting that and saying, actually, the system has to proceed on the basis that unless it can be proven beyond reasonable doubt you're guilty, we will treat you as innocent. Other parts of the system have seen that eroded, and my view is that law needs to protect that, not accommodate it. But I think partly because of the way in which Parliament has approached it, it has been accommodated. That sort of view of the majority that a lot of people are in fact guilty when they were acquitted.
Thanks very much, Hugh. I think we will all see what happens with Hallam and Nealon in Strasbourg with interest, and see if Strasbourg finally really takes the sort of domestic conceptualization of miscarriage of justice in the UK and says something definitive about it. Thanks very much for talking to us today, Hugh. It was a pleasure discussing what was a very complex, very nuanced, but a very impactful topic, I think, on many people. So thanks very much for coming today.
Thank you for having me.